All right, we continue our legal analysis on what we saw unfolding inside court GD today with Judge Thokozile Masipa delivering the first part of this two-part judgment. Just to also say that we are not doing the analysis as part of a critique of her judgment, but rather as an explanation for our viewers as to how this judgment is digested and how better to understand it. And for those of you who are just joining Newsnight for the first time, now eNCA for the first time, let's perhaps go back with Michael Motsoeneng from Motsoeneng Bill Attorneys about from the very start, how the perception of the delivery of this judgment has gone down. There was some surprise in legal circles, and we saw a Facebook posting a short while ago, Michael, from one of the members of the NPA basically saying, what is the judge doing? So there is some surprise. How did you interpret the first part of this judgment?
Well, I'm among the people who were surprised because I certainly thought that intention had been proved, and intention in the form of dolus eventualis. So it did take me by a big surprise when she excluded that as a possible grounds for conviction. And
dolus eventualis, just for the benefit of those viewers who don't understand, is the consequence of an action, the natural result of which is something that the accused takes into consideration. Perhaps just sketch it out for us, dolus eventualis, and also how that kind of interleaves with this concept of a reasonable foresight. And there's some debate about whether the judge has traversed both of those and perhaps mixed those two principles up in some way.
Well, when we're talking about intention, we don't inquire into reasonableness, because that's where you're inquiring into negligence, because then that's where you'd be concerned about the reasonable person. How would a reasonable person act? When you're looking at intention, in fact, in this case, you've got two types of intention. You've got dolus directus, which is I point a gun at A, I pull the trigger and I shoot A, and A dies. So I intended to do that, so it's direct intention. Now, how we have dolus directus is almost you construct this intention. It's not your typical direct intention. It's constructed intention, and we call it dolus eventualis. And how that works is, if I shoot, for example, if I set grass alight, a dry grass alight, but before I set it alight, I see that few meters down the line there's a car next to the grass, and I nevertheless foresee that possibility that if I set this grass alight, that car will burn as a result. But I reconcile myself to that possibility and I say, you know what, I'm going to set the grass alight anyway. So when you look at my direct intention was to burn the grass, but the eventualis, that's the sort of almost indirect intention or constructive intention, is that as a result of the burning of the grass, I foresaw that I will also burn the car, but I reconciled myself when I proceeded anyway. So that's how we come to this thing called dolus.
So how did these themes around, Oscar Pistorius's intention and all of that play into how Masipa would have constructed and mapped all of these things out, with the consequence of taking both murder and premeditated murder off the table?
So premeditated murder was always a long shot, because, what do you have to support that? We have loving text messages or text exchanges. We have no real evidence of any arguments before. The only thing that we have is a neighbor alleging that there was a scream of a woman. And Judge Masipa, when she began a judgment, I thought, well, of course, because that doesn't really take us any far. Even if there was an argument, and even if they did argue before the killing, it doesn't necessarily mean that if I argue with you, I'm going to kill you. So I do appreciate that. Obviously, those are circumstantial factors that you got to take into account, but it doesn't necessarily follow. So premeditated murder was always out of the cards for me. What did exist was the issue of dolus eventualis, because of course there is no evidence that Oscar Pistorius intended to kill Reeva Steenkamp. Certainly not. So we accept that. But what we can't accept, what we can't overcome, is in conducting himself in the manner that he did, in arming himself, proceeding to approach the danger, arriving at the place of the perceived danger, firing a whole 4 shots at a closed door. That becomes, you ought to have so at that point, remember my example about grass. At that point, you're thinking, if I pull this trigger, there could be somebody behind that door, and I could injure them or even kill them. But I'm going to do it anyway, and perchance it doesn't happen. And when you really think about it, the identity of the person behind the door is immaterial as far as I'm concerned. Because even if it was a burglar, as Gerrie had said initially during I think his closing argument, even if it was a burglar, that burglar did not deserve to die. The only time you can justify the shooting of a burglar is when that burglar poses imminent harm or danger to you. And this was not established because the door was closed in this case. And
Yep.
I know you want to proceed, but I was thinking about something when I was waiting. Imagine this. Imagine it was not a burglar. It was somebody who brought a baby to just dump the baby in the bathroom and abandon that baby, as that typically happens. You either leave a child at a door or you put him through a window and make that baby somebody's problem. It means that baby, because there was a rattle in the bathroom, that baby would have now been dead.
I mean, it certainly is interesting, and one imagines that tonight these are aspects that the NPA is taking a really close look at in terms of how they will proceed, particularly at the conclusion of tomorrow, about a possible appeal. And that's something we'll explore with you in just a short while. The States, of course, spending a lot of time on the series of WhatsApp messages between Pistorius and Steenkamp. But Judge Masipa is saying today those messages don't prove anything.
In support of this theory, State Counsel pointed to the fact that, amongst other things, the deceased had a cell phone with her and had locked herself inside the toilet. In my view, there could be a number of reasons why the deceased felt the need to take her cell phone with her to the toilet. One of the possible reasons may be that the deceased needed to use her cell phone for lighting purposes, as the light in the toilet was not working. To try to pick just one reason would be to delve into the realm of speculation. The state also led the evidence of WhatsApp messages that went to and fro the accused and the deceased a few weeks before the deceased was killed. The purpose of such evidence was to demonstrate to this court that the relationship between the accused and the deceased was on the rocks, and that the accused had a good reason to want to kill the deceased. In a bid to persuade this court otherwise, the defendant or the defense placed on record more WhatsApp messages that painted a picture of a loving couple. In my view, none of this evidence from the state or from the defense proves anything. Normal relationships are dynamic and unpredictable most of the times, while human beings are fickle. Neither the evidence of a loving relationship nor of a relationship turned sour can assist this court to determine whether the accused had the requisite intention to kill the deceased. For that reason, this court refrains from making inferences one way or the other in this regard.
So the question remains, why did Oscar shoot? Judge Masipa outlined his options on the night he killed Reeva Steenkamp.
The accused would not have been expected to run from the danger. However, there were other means available to him to deal with what he considered a threat to his life. Security personnel are there to deal with such threats or emergencies. All the accused had to do was to pick up his cell phone to call security or the police. He could have run to the balcony and screamed in the same way he had screamed after the incident. He was able to call security after the incident. There is no reason or no explanation why he could not do so before he ventured into the bathroom with a loaded firearm. Calling security, calling Stander, and running to the balcony to scream for help and to attract attention probably would have taken as much time, if not less, as it took to go to the bathroom and to discharge those 4 shots. It is also significant that at the time that the accused had the window slide open, he was nearer to the balcony than to the bathroom.
And we saw so much discussion, Michael Motsoeneng, and so much unprecedented interest in this trial. Of course, it was the first time. It was historic. It was broadcast and televised, and people were taken inside court. We saw this overwhelming interest in the witness testimony, in the way things unfolded, in particular those WhatsApp messages, all of which we saw the judge pretty much just put aside. Were you surprised that she didn't go in detail, as we've seen in other courts, through witness testimony, the individual 37 witness testimonies, and decide, you know, who she believed, who she didn't, who she found wanting? Instead, just showed us what Karen Moore describes as the highlights package.
And it is about the highlights. You know, we don't want to have a regurgitation of the evidence that was tendered. You got to deal with the highlights, and the highlights are not what is fun and interesting, but it is what is material, legally material. Mm-hmm. And that's what she confined herself to, and that's what she ought to have done, because it's no point you have a lengthy judgment with which has no real substance to it. So I think that the speed with which she's going, the precision with which she's dealing with the issues is quite remarkable and indicative of her experience as a jurist. So that's quite impressive.
Masipa also said, Michael Motsoeneng, that Oscar Pistorius was not candid, and that certain questions will remain unanswered or remain an issue of conjecture. Based on her assessments about this evidence, how much do we actually know through these 41 days and these 37 witnesses? How much do we actually know about the truth of what happened on that night?
Well, we don't, and that's the predicament that the judge faces. You see, the judge is not, you know, the judge doesn't ask the question, how much do we know about the truth? She asks one question: has the state discharged the onus of proving beyond a reasonable doubt that this person has committed murder and that this person was possessed of the requisite intent?
Well, she's given them a failed score in that regard.
Exactly. So that's the inquiry. It's beyond a reasonable doubt. And you can imagine that. That's a very tall order, because in her mind there must be no reasonable doubt that the state is, before the state can be successful. It's not in a civil matter. In a civil matter, if you're suing somebody for payment of money, you don't have to prove beyond a reasonable doubt. You have to show on a balance of probabilities. And that's quite an easy onus to overcome, as opposed to this one. So Gerrie did, of course, have that big hurdle to overcome. And as you quite correctly put it, he was not given a favorable mark. It
seems a fait accompli, Michael Motsoeneng, that he will be convicted of culpable homicide. What is your call tonight? And of possible sentencing? I know that's a tall order.
Yeah, the sentence is obviously a difficult thing, but obviously she's already hinted on culpable homicide, so it's not much of a guess, because she's already given us the hints that that's where she's headed. So I don't think that she, you know, with the information that she's already given us so far, it'd be very difficult for her to then move and quit.
I guess what I'm really asking you is, you know, for a lot of people who are asking, will there be time? Will he serve time?
Oh no, we can never know that, and that's a very important question, because you gotta, you know, this is one process, this is one leg. The other leg that is to follow is sentencing, and before you can get to sentencing, you then gotta give the state, on the one hand, an opportunity to advance aggravating circumstances. That is, you know, as an example of an aggravating circumstance is to show the conduct of Oscar Pistorius and his personal circumstances, how those personal circumstances should have actually led him to behave in a better way. For example, the fact that he's undergone such vigorous training to obtain his gun license is actually an aggravating factor. The defense, on the other hand, would advance mitigating factors. That is to show, but this accused person is a disabled person, and you've heard from doctors that he suffers from a startle response disorder, and all of those things are going to be heard, and the fact that he's paranoid, the fact that all of those things that we've heard during the testimony are going to be repeated as mitigation. And then they're going to ask the judge, say, Judge, because of all these mitigating factors, because this person actually loved Reeva Steenkamp, because you could see from the messages that they generally had a loving, ek is lief vir jou my baba, and all of those things. So these people, it's somebody who the previous day didn't wake up thinking that they're going to murder somebody, or they're going to kill somebody. And unfortunately, this happened in circumstances which he did not intend, and he did not wake up thinking that he's going to be faced with that situation. So we think that he should not be subjected to direct imprisonment, and we should rather explore alternative sentences.
I mean, Michael Motsoeneng, lives are in the balance, one life is lost, but the explanation of the way the court works and all the different potential for what could happen is truly fascinating, and thank you for helping us to navigate that. Michael Motsoeneng giving us his perspective on this ongoing judgment.